Fund for Protection of Investor Rights in Foreign States filed a lawsuit against the Trust Bank, its former owners and top managers Ilya Yurov, Sergei Belyaev and Nikolai Fetisov, as well as their wives. The lawsuit was filed on 15th of April this year.
Фонд защиты прав инвесторов в иностранных государствах действует на основе уступки прав требований, заключенной с обманутыми вкладчиками банка Траст. Обращение в английский суд обусловлено тем, что господа Юров и Фетисов и их жены в настоящее время проживают в Великобритании, поэтому данный иск будет рассматриваться в Лондоне.
In addition, 4 years ago, in 2016, the Bank Trust filed a lawsuit against the former owners and top managers of the bank, as well as their wives, in the High Court of Justice in London, thereby agreeing with the jurisdiction of the court. The bank demanded compensation for damage caused by fraudulent actions of Yurov, Fetisov and Belyaev in the amount of more than $900 million. The lawsuit was fully satisfied as evidenced by the decision of High Court of Justice in London as of 23 January 2020. Yurov, Fetisov and Belyaev, being the owners and top managers of the Trust Bank, had the opportunity to organize the adoption of any decision on behalf of the bank. These persons were engaged in activities that were contrary to the interests of the Trust Bank. They carried out the theft of bank funds in especially large amounts. They organized approval at the credit committee and entered into bank loans and other transactions that were knowingly unfavorable for the bank, and other transactions with the shell companies controlled by them, from which they received personal benefits through a network of intermediaries. The constant theft of funds led to a formation of a hole in the capital of Trust Bank, which would inevitably lead to a decrease in the bank's financial indicators below the level established by law, and bankruptcy of the bank. In order to extend the period of embezzlement of funds, the former owners and top managers needed to come out with a scheme for replenishing the bank's own capital, which would preserve the appearance of financial well-being. As such scheme, top managers through Trust Bank concluded subordinate loans and sold cradling notes to its depositors. Subordinate loans were provided to Trust Bank by two companies under its control registered in Netherlands. The total amount of loans in dollars amounted to approximately $400 million. Cradling notes were sold exclusively to Trust Bank depositors, first of all to VIP depositors whom had deposits larger than 3 million rubles on the deposit accounts in the bank. Cradling notes were offered to bank depositors who did not have the slightest idea about the nature of cradling notes. They were not presented with the documents on basis of which subordinate loans were provided. Meanwhile, these documents contained the entire list of risks associated with subordinate loans. These documents state that purchasers of notes bear the risk of absolute loss in respect of the principal amount. Before making a decision on investing, future buyers of notes should carefully analyze the risks, taking into account their own financial situation and investment objectives. All the information was contained in the documents on the provision of subordinate loans. Instead, the managers of Trust Bank, with whom the bank depositors had trusting relationships, carried out explanatory work on the basis of a script developed in the bank. The script contained false, misleading information that the credit-linked notes, in terms of risks, are no different from deposits, and the interest rate on them is, or in future will be higher than the constantly decreasing deposit rate. As a result of the intensive work carried out by the managers of the bank and the psychological pressure based on full trust, hundreds of former bank depositors, not understanding the essence and consequences of their actions, agreed to transfer the funds stored on their deposit accounts with the bank trust to credit-linked notes. From the point of view of legislation of Russian Federation, only so-called qualified investors could be buyers of credit-linked notes. It was assumed that a qualified investor is a person with experience and special knowledge in the securities market. The legal acts of the Russian Federation, in addition to general requirements, contained formal requirements that had to be fulfilled in order to obtain the status of a qualified investor. For example, the sale and purchase of a certain amount of securities. Trust Bank fulfilled the specified requirements independently on behalf of depositors without their direct participation, and then it recognized the status of a qualified investor for each of the potential holders of CLNs, while realizing that none of these persons had a real idea of working in the securities market. As a result, the bank in fact made transactions on the sale of credit-linked notes with itself. Funds, without leaving the bank, migrated from accounts of deposits to loans provided by two Dutch companies to Trust Bank, becoming part of its own capital, partially covering the whole and thereby extending the period when the former owners and top managers of Trust Bank could keep embezzling the funds through shell companies. This kind of situation cannot last forever. At the end of 2014, it ended in default, as a result of which credit-linked notes, legally or actually, depending on series of issue, were cancelled. Thus, the holders of credit-linked notes lost both money invested in the credit-linked notes and the opportunity to receive interest on them. A few words about the legal circumstances of the case. The lawyer of the Fund for Protection of Investor Rights in Foreign States, Doctor of Law Professor Zenkin, states that during the period of sale of credit-linked notes, the bank falsified its financial statements, showing the level of equity above the minimum required by law. As of April 1, 2013, this indicator of Trust Bank was 10.3. However, according to the data established by High Court of Justice in the process of considering of a claim of Trust Bank against its former owners, from 2012 to 2014 it ranged from 6.7 up to 7.4. That is, it was lower than established norm by the central bank, which amounts to 10%. That is, actual indicators show that Trust Bank was in a state of default for a long period of time before 2014, and the government was obliged to take measures for its financial recovery or bankruptcy. Being in such a heavy financial situation, the bank was not entitled to conclude agreements on obtaining subordinate loans, since this contradicts the essence of such loans and turns them into a tool of fraud. At the same time, the bank concluded such agreements. Moreover, the bank attracted its own depositors to participate in loans, which it had no right to do based on terms of subordinate loan agreements. It should be noted that before the first trials in Russia, when the lawyers requested subordinate loan agreements, neither the bank depositors who purchased the credit-linked notes nor the bank managers who sold them were familiar with these documents and therefore did not understand their essence. The employees of the bank, whom had trusting relationships with the purchasers of credit-linked notes, sold financial instruments on basis of the false information and assurances, which were subject to cancellation at the time of their sale, because the real financial indicators of the bank were at the level of bankruptcy. Thus, there was a violation of criminal legislation of Russian Federation, civil legislation of Russian Federation, legislation on the work on securities market, and legislation on the protection of consumer rights.
В настоящее время Банк России является основным акционером Банка Траст. Центральному банку принадлежит более 95% акций Траста. В связи с этим мы считаем, что Банк России должен нести ответственность по обязательствам своего дочернего предприятия Банка Траст.
Current Russian legislation and the law enforcement practice of Russian courts allow a participant to be liable for the obligation of subsidiary if the company is unable to fulfill its obligations. It should also be noted that in accordance with Article 6 of the Law of Central Bank of Russian Federation, the Bank of Russia has the right to apply to foreign courts for protection of its interests. The following conclusions can be drawn from this provision. The Bank of Russia recognizes the jurisdiction of foreign courts. This includes the courts of Great Britain, in particular the High Court of Justice. The Bank of Russia may act in foreign court either as a plaintiff or defendant, in some cases even as a third party. In accordance with general requirements of private international law, the applicable law in this case, despite the fact that the case will be heard in English courts, is Russian law. Based on the applicable provisions of Russian law, the fund requires defendants the following: compensation for real damage, reimbursement of interest for use of other people's money, compensation for lost profits, payment of the fine under paragraph 6 of Article 13 on the Law of Protection of Consumer Rights, an amount awarded by the courts. The calculation of the amount of the claim will be prepared and submitted to the court by the time the decision is made, as this will allow to correctly take into account the interest calculated depending on the number of days of delay. In general, if we look at the persons who have already concluded cession agreements with the fund, the amount of claims amounts to about $3 million.